Hello there, everyone. Judge Andrew Napolitano here with a pop-up on Judging Freedom. Today is Friday, January 21st, 2022. It's about 1:40 in the afternoon on the East Coast of the United States. Last night, the Supreme Court issued another decision in the Texas abortion case. This case is almost setting a record for the number of decisions by the Supreme Court of the United States. And the purpose of this pop-up is for me to unpack it for you, to do my best to explain it to you. The reason this case keeps going to the Supreme Court is because people, abortion providers, and women who are seeking abortions where the baby in the womb is more than 6 weeks old, keep challenging the Texas statute. And some of these challenges are in federal court, and some of the challenges are in state court. And the challenges are being treated differently. But the principal challenge in federal court in Texas, the Texas statute was enjoined. That is, a federal district court judge prevented the state from enjoining it. Why? Well, the Texas statute does not permit abortions after 6 weeks. And the current law in the United States, which is the Supreme Court opinion of January 1973, is Roe versus Wade, and that says that the states cannot interfere with abortions during the first trimester of pregnancy or up until viability, which is roughly 23 or 24 weeks. Supreme Court has voted twice now by a vote of 6-3 to allow the Texas statute to stay in force in Texas while the case is being challenged in the trial courts below. That's pretty basic. What has complicated this is that a state judge in Texas has found that the statute is unconstitutional because it violates the Roe versus Wade. A federal judge in Texas already found it unconstitutional. That judge was reversed by the United States Court of Appeals for the Fifth Circuit, which sits in New Orleans but covers Louisiana, Mississippi, and Texas. And then the Supreme Court upheld that decision. So the Texas abortion providers went to the Supreme Court yesterday and said, would you put the statute on hold while the state judge's opinion is being appealed? And the Supreme Court said, no, we won't put it on hold. In fact, we're going to send it directly to the Texas Supreme Court because it's going to make its way there anyway. This is most unusual. The case is filed in a Texas trial court. The government loses. The challengers win. The challengers go directly to the Supreme Court of the United States, which says you're in the wrong place. We're going to send it back to the Texas state system, but we're sending it to the Texas Supreme Court because it has to go there anyway. So 2 Supreme Courts will soon rule on this. The Supreme Court of the United States has ruled preliminarily by a vote of 6-3. That the Texas statute is probably constitutional and probably will be upheld. Now, that is a profound decision because that permits the legislature of the state of Texas to engage in what Thomas Jefferson and James Madison, remember them, referred to as nullification. Nullification occurs when the legislature of a state or the highest court of a state purports to nullify a federal ruling or a federal law or a federal decision and saying it doesn't apply here. Well, that's what happened when the Texas legislature, and the governor signed this into law. So the legislature enacts a statute, passes a statute, the governor signs it, a Texas law nullifies Roe versus Wade, which says the states can't interfere with abortions up to 23 weeks by saying we're going to ban all abortions after 6 weeks. The Supreme Court is permitting this nullification. This is profound, and it cuts both ways. I mean, what the Texas legislature did to nullify Roe versus Wade, look out, because the California legislature might purport to nullify Heller versus District of Columbia, which is the Supreme Court opinion that says the right to keep and bear arms is a personal freedom. So this nullification stuff can get a little dangerous. I am in favor of it. I like the idea, as Ronald Reagan used to say, of voting with your feet. If you don't like the laws in California, you can go to Texas. I know it's not easy to move to Texas. It's not easy to move anywhere. But when the laws are different in each state, there's a lot more choices. Okay, last night was the last time I think this case will go before the Supreme Court of the United States, and it ruled again 6-3. This is the state appeal saying we're sending this back to the Texas Supreme Court. The Texas Supreme Court will no doubt uphold this statute, and then the case will make its way back to the Supreme Court of the United States. When it gets back there, I don't know, because the Supreme Court has already heard oral argument on a similar case from Mississippi, which bans abortions after 15 weeks. And the Attorney General of Mississippi, a former clerk for the late Justice Antonin Scalia, has asked the Supreme Court to invalidate Roe versus Wade. In my opinion, the court will invalidate Roe versus Wade, which then will leave all abortion laws up to the states. If you're pro-life, that's a good thing and a bad thing. It's good because it will allow states like Texas to stop abortions altogether or after 6 weeks. It's a bad thing because it will allow states like New Jersey to permit abortions up to the moment before birth and to pay for them. My boyhood friend and college classmate who sits on the Supreme Court, Justice Samuel Alito, offered during oral argument in the Mississippi case, well, doesn't the baby in the womb have an interest in staying alive? Now, such words have never been uttered in abortion cases in the Supreme Court of the United States. Translation, the baby in the womb is a person. If the baby in the womb is a person, then all abortion is unlawful because the states are required under the 14th Amendment to protect life, liberty, and property of all persons. Hard to predict which way this will go, except to say I do believe Roe versus Wade is on its deathbed. Judge Napolitano, Judging Freedom.